Hello, I'm Professor Christine Coughlin. Today we are going to discuss the basics of legal research. Conducting legal research is an integral part of being a legal professional. You need good legal research skills to do just about anything well: succeed in law school, obtain a summer internship, land a job, and represent your future clients. When students think about legal research, one of two images often comes to mind. The first is that of some huge library or file room where exhausted workers spend countless hours pulling out books or going through dusty old records. The second is that of an online search engine. After all, who really needs to learn how to research when you can type whatever you need into an online query? Neither image is correct. Because of technological advances, the days of a treasure hunt to find a particular legal source are over. However, because there are so many sources of laws and ways to approach legal questions, it's far more effective to develop good legal research skills than to simply type ideas into a search engine and hope something useful pops up. You are probably aware of how inaccurate and outdated information from the internet may be. Just as your doctor doesn't trust you when you tell her you've diagnosed yourself based on an online search, you don't want to end up billing your client for information you later learned was an internet hoax. So because of how busy you'll be as a law student and as a lawyer, investing in learning how to research smarter will help you save time and energy while also making you a better lawyer. Where the law comes from. The purpose of legal research is to pin down the relevant law in relation to the issue and the facts of your client's case. It can be challenging for beginners due to the complex, nuanced, and evolutionary nature of the law. So to learn legal research, you must first understand how our law is created. Professor Duncan covered some of this earlier, but a refresher won't hurt. The Constitution, our preeminent source of law, dictates the way that law is created. In the United States, the principle of federalism splits the governing power between the federal government and the various state governments. The federal government is broken down into three branches: the executive branch, the legislative branch, and the judicial branch. The breakdown of state governments generally mirrors that of the federal government. Each branch provides different sources of law. At the federal level, the Constitution named Congress as the primary source of law. Laws passed by Congress are commonly known as statutes. Congress, however, sometimes delegates its lawmaking power to executive agencies that manage certain complex areas of law on Congress's behalf. These administrative agencies, which are part of the executive branch, create regulations to implement the broader legal policies in the statutes. For example, the Environmental Protection Agency might create regulations about wastewater treatment, sludge, or fracking. The judicial branch of government is charged with the power of judicial review, enabling courts to interpret the meaning of statutes and regulations, as well as ensure that those policies conform to the Constitution. Finally, the judicial branch shapes the common law. Common law is often referred to as judge-made law. Particularly at the state level, many common law principles exist only because the courts in different states develop their own legal frameworks over time. Much of state law from your first-year courses of torts, properties, and contracts is of common law origin. Because the judicial branch both interprets the statutes and regulations and shapes the common law, the law often evolves over time. We actually have two completely different court systems in our country: the federal court system and the state court system. Each system is hierarchical in nature. At the top of the federal system sits the U.S. Supreme Court. Beneath the Supreme Court are 13 federal circuit courts of appeal. Beneath those are 94 federal district courts. Circuit courts review cases on appeal from the district courts for errors. There are also some specialty trial courts in the federal circuit that have jurisdiction over all cases involving certain topics, such as bankruptcy. State court systems are very similar, but do vary in their structures depending on the state. Whether a decision by a particular court is binding on other courts depends on the weight that decision is given, a principle known as stare decisis. Stare decisis is Latin for, how do I pronounce this? Just kidding. Stare decisis is actually Latin for, to stand by things decided. Essentially, this means that courts must follow judicial decisions of courts that are further up the hierarchy within that jurisdiction. You will learn about the different types of jurisdiction in your civil procedure class, but for right now, think of jurisdiction as simply the power of a court to hear a case. There are two types of stare decisis, horizontal and vertical. Horizontal stare decisis dictates that courts must adhere to prior decisions of that particular court unless it finds a compelling reason to overrule a past legal standard. Vertical stare decisis mandates that lower courts must follow the rulings of a higher court. Due to federalism, state court systems operate separately from federal courts, but their own decisions are still bound by both the U.S. Supreme Court decisions and relevant circuit court rulings. As if all that weren't enough, there are even more non-binding sources of law that can help you figure out your legal problem. These are interpretive sources that give an overview or critique of a particular legal area. These sources might include non-binding cases, legislative histories, treatises, legal encyclopedias, law review articles, journal articles, digests, and legal restatements. These are often called secondary sources, distinguishing them from binding primary sources. Tips for success as a legal researcher. One of my smartest students came up with the dumb method of legal research. D, develop good research plans. U, use all of the free resources you will get in law school. And M and B, manage and balance your time well. Let's look at each of these steps. D, develop good research plans. Like building a castle out of Legos and not being sure which bricks you need, good legal research requires identifying and collecting many different sources. You then need to analyze these legal building blocks and understand how the individual pieces fit together. Unlike Legos, however, there usually isn't a handy instruction guide to walk you through the steps to build your final, in this case, legal product. There are, however, time-tested principles that will prevent you from missing important information during the resource process and keep you on track. Principle 1. If you don't have a solid grasp on an area of law, start with secondary sources such as treatises or restatements to get an overview of the subject. Principle 2. Because of stare decisis, narrow your research to those jurisdictions that are binding in your case before resorting to non-binding courts. To illustrate this principle, let's say that you are researching a Georgia state issue concerning assumption of the risk. While you may find a similar case, it is from a state court in California. That case, while factually similar, may not be the best case for you to rely on in court because the California case would not be binding on the Georgia court. And principle 3, always organize your research by creating folders, printing important sources, notating or charting important information. This will help keep track of your sources and see themes, patterns, and trends in the law. Use as many free resources as possible while in school. One of the great things about being a student is that you have access to all sorts of legal resources for free. Once students become practicing attorneys, though, these sources are limited and expensive. One way to use free legal resources is by attending the lunch seminars and workshops offered by legal research companies. Not only is this training invaluable, but also students often get free pizzas and gifts while they learn. In addition to research seminars, students should also take advantage of the vast amount of legal information available in their library. Learning to navigate hard copies of sources can be very helpful in understanding the breadth of a certain database. M&B, manage and balance your time well. In the fray that is the first year of law school, students often make the mistake of burying legal research skills at the bottom of their to-do list. Some students may think it is practical to ignore their legal research classes and extra training in favor of preparing for other classes. There is not enough caffeine in the world to give students back the time and energy they will lose later in law school and life by making this critical mistake. Instead, to become a time-effective and efficient researcher, you must balance your time and commit yourself wholeheartedly to learning the research process. In conclusion, Legal research skills are vital for success in law school, for summer internships and jobs, and in representing clients. We hope that this brief overview will help you in capitalizing on opportunities to learn effective and efficient legal research strategies. Let's proceed to the self-assessment.